Good morning, everyone. My name is Jesse Fenty, as she said. I'm a Howard University graduate, 1996, electrical engineering. I work as an intellectual property attorney, Washington, D.C., licensed in Virginia. I do patent drafting, patent filing, I do trademark work, and I do a lot of teaching of intellectual property concepts to engineers at the undergraduate level, at the high school level, and different things. And so Valencia, this is a fantastic conversation because I've known Valencia for a long time. She was, I worked at the patent office, she worked at the patent office. I joined there in '98, and we were in the same group. She was my senior, she was one of my supervisors, you know. And so this conversation is almost going to be like a regular conversation we would have over coffee. And we would, you know, and we're both in the space of empowering people about intellectual property and doing this work. And Valencia's had a great career at the PTO. I'm going to let her introduce herself and tell us what she's been doing for the last 25, 30 years.
Great. Thanks, Jesse. And good morning to everyone. So happy to have you, to be here with all of you. And yes, Jesse and I had an opportunity years ago. I am also an HU grad, 89 from the engineering school in electrical engineering. Jesse and I had a great opportunity to get to know each other and work together at the USPTO as examiners. I stayed at the office. I actually, Jesse and I both went through law school at the USPTO. They have a program that will help support money-wise with getting through law school. So I was here at Howard, then I went to George Washington and worked at the USPTO as an examiner. Stayed there and worked in the semiconductor space as an examiner there, and then worked as in the software area as a supervisor, and also in the as a director there. So as an executive, first line executive as a director there at the USPTO in the software space. And then I had an opportunity to work as assistant deputy commissioner before moving on to the position of deputy commissioner, where originally I started in the area of patent quality, so dealing with addressing a lot of the issues and how do we keep examiners abreast of the laws and the technology in order to do the best job they can at of allowing applications that become patents. And now I'm working in the space as a deputy commissioner on the international front, international harmonization with IPOs, which are intellectual property offices across the globe, to work on how to harmonize the IP protection in every country, because just getting a patent here at the USPTO does not protect you in other countries. So working through that space. I also have a great opportunity, which allowed me to start spending more time with Jesse as well, to lead a program for the Undersecretary of the USPTO in the space of inclusion in the IP and innovation systems. So how do we as the USPTO work with and partner with organizations across the entire sector of the innovation, all sectors of the innovation community, to include and provide equity to all those underserved within intellectual property and innovation. So that's women, that's Black Americans, that's Hispanic Americans, Native Americans. How do we work together to make sure that we are all included and not leaving IP, unidentified ideas out there, and making sure that we're nurturing and supporting all innovators across our country. So Jesse and I have had some opportunities to speak on that as well.
This is a fantastic topic. I mean, intellectual property is one of those areas that is in society. People know about trademarks. I mean, everybody knows about brands. The patent space is an area that we both know very well, but we know that it's not known in our community to the extent that it should be. And so we're super excited to do this work that we do and to be able to talk to you all about some things that we know and share some things going forward. So even just stepping back for a moment, so last night we had a nice tribute to Dr. Gary Harris, engineering professor at Howard University that we both studied under. And so, you didn't get a chance last night to be there, and people gave a lot of, stirring comments about what he meant to them and what he did. And it's nice to, we had a nice libation earlier to the ancestors, and so just one more time to hear your view about Dr. Harrison, what he did for you, what he meant to you would be nice to hear.
Thanks, Jesse. I wish I had the opportunity to be there last night to share, but I'd love to share today. Dr. Harris was pivotal in my career on many points. As an engineering student, I trained under him in the solid-state devices, specifically semiconductor area, and as I mentioned, that's an area that I went into in examination. So he really helped start my career at the USPTO by learning from him and having the support that he gave us in exploring semiconductors and solid-state devices. But even beyond that, when I decided I wanted to go to law school, I had already left I graduated from Howard, and I came back and talked to him about it, and he gave me a reference that helped get me into law school to further my career, which is something that I think anyone who ever knew him knows, that he will always be there to help uplift and advance. Even though he's not earthly with us anymore, I think his spirit is still with us to uplift and advance and inspire, as he did with the foundation of this summit and even beyond.
Great. All right, so let's get into some patent office talk. So what should startup founders know about the USPTO?
So first, know that there's more than utility patents. There are many different types of IP, but let's start with utility patents, in that you don't have to be a rocket scientist to get a patent, a rocket scientist to be a patent, right? You can get a patent for shoelaces. You can get a patent for and it's very lucrative for Nike and Adidas for the tennis shoe. Anything that has utility, anything that has use, that comes to your mind, an idea that comes to your mind that has use in any space, is the possibility of a patent. So don't ever think somebody else has already done it. Don't ever think it's not enough until you go through the process and you do research to look and see what else is out there. Because you not only receive a patent for a brand new idea that no one has ever thought of, but if you create something that's not obvious from what already exists, something brand new out of what someone else has already done that no one could have thought of to do, you deserve a patent for that as well. Another thing you should know about are design patents, which I think don't get the exposure and the value that they deserve, because getting a utility patent, say, the chair that you're sitting on right now, it has a use. You're sitting on it, so you can get a utility patent. But the look of that, the design of that patent, the print on that, on that chair, also deserves, if it's unique, not done before, it also deserves a different type of patent, a design patent. There are other things as well as trademarks. So if you're...
All right, let's stay with patents for a
second.
second.
We're sticking with patents. Okay, I'm going too far for it.
No, we're going to get there. I want to clarify for the audience, and so I teach a lot in this space. So what is a patent? We talk about you can protect something with it. So I tend to break down a patent into three different things. I think it's an engineering document, it's a legal document, and it's a contract with the government. So what is a patent? So it's a property right, So why is it an engineering document? Let me ask you that. What's in it?
So if there's something, as I mentioned, if there's a use to it, then it is something that's part of your idea, your intellectual property, which means you have an opportunity for the life of 20 years to protect how that idea, whether it is a high-tech idea like a metaverse or NFTs, high-tech, or as simple as I said, a shoelace. If it is your idea and you've gone through the process of the USPTO to have this contract, this patent, it says you for 20 years are the only person who can use that. And it is your choice at that point to then license it to others. They have to pay you to use that idea.
So what's the process? So do I just submit an idea? Is it just a one-page document? So I have this idea for this chair that does this. Is that enough to have this described as the idea? Like, what do you need to show?
So you have to show several things when you are applying for a patent. You have to disclose, you have to have a full disclosure, so that disclosure provides background of this idea. You know, what do you know of this idea, of that chair? If you know of others who have created a chair like this, what's that background? And then you describe in detail how what you're doing is different from that. And you provide figures for that as well. This is what it looks like. That all goes into your patent. And then you provide claims. I claim this as my idea. The first claim, your independent claim, is your broadest claim that says, I'm going to make it as simple as possible, but it goes into more detail, a chair. A chair that has 4 legs and a backing with a metal brace around it. You make that first independent claim as broad as you can. That still does not infringe on anyone else's ideas. And then later, dependent claims start adding in more ideas about it. It's a steel frame. The chair has 4 legs that are equidistant apart. Things that start helping to protect more of your idea. But what you want to do with your independent claim is make it as broad as you can without infringing on others. That gives you the broadest protection.
So what's this purpose then? Most people think they have an invention idea and they want to keep it secret. I got this idea and I want to keep it secret, this business idea, I don't want to tell anybody. Why am I telling the government my idea and explaining to them how you made it? Why am I doing that?
First off, if it's your idea and you have not filed a patent, then yeah, you shouldn't tell other people because you don't want anybody else stealing your idea, right? When you file an application with the USPTO or any other IPO, any other IP office within our globe, you're saying, this is my idea, I am filing it with you right now. What's the date in which I can now start telling people I filed this application and it is under review? That's when your protection starts for when you have a patent. That's your filing date that says, and that's the system that we now work from that's harmonized with other countries is first inventor to file. That's what you need to do in order to start the protection. Because if someone has, on the other side of the globe, right, has the exact same idea as you and decides, I want to get protection in the United States, I'm going to file. Even if you've done it first, they were the first one to file within the USPTO, therefore they get the right to that idea. So that's why you want to file with the USPTO as soon as you've put your idea in that form where you've described it, you have put it down, you have really honed into what your idea is that is not like anyone else's, and then start claiming it.
Right, so I called it an engineering document. It's not, you don't have to be an engineer per se, but you have to describe your invention in a way that someone else can make or use it. So you're giving the government, you're giving the public the benefit of your knowledge, and in return, the government is giving you this fixed time period that Valencia talked about before, this fixed time period to monopolize your idea. And then by dedicating your document to the public, you give them the chance to understand how your technology works, and then they can improve upon that. And that's the whole system of the patent system. And it's a fantastic system because it's socialistic and capitalistic at the same time. People tend to frown upon socialism, but the patent system is giving the public that information that we can build on. So that's patents. And so there's other types of IP that you were going to talk about, trademarks and yeah.
And, you know, especially looking at the purpose of this summit and looking at blockchain, look at NFTs, metaverse. There's a utility to that in the metaverse, right? You're developing a game that someone is inside of. So you can get, because it's useful, and that's called a 101. 35 USC 101 is the statute that governs that protection. Says you can file because it's useful. But you've created this whole new world, right, in the metaverse. It has a very specific design to it. It looks a specific way, just like that chair looks a specific way. That's where design patents come in. The utility patent says it's useful and no one's ever done it. The design patent says it looks exactly like this and no one has done it. So you can also file to protect the look of what you've done. Trademarks, if you're starting a company based on what you've created, you want to have a particular name of your company. You may want to have particular taglines in order to protect that so no one else can use it in the space that you're using it in. You file for a trademark. Same thing with copyright. If you have a design, you have a painting, you have something, whatever that look is, you can file for a copyright as well. The difference between design patents and copyrights and trademarks, so it's the look of it, but its design is a patent as well. It's a substantive examination from the Office of the USPTO as to what you've created in that design, and you get a patent for it. Trademarks and copyrights are registrations. It's not as intense. So in most cases, you're going to get those a little quicker, and you're going to get it a lot easier. So I would explore all of those different areas.
Right, they're tools of business. We were talking earlier about this. I mean, intellectual property is a tool of business. It doesn't guarantee if you get a patent that you're going to make a bunch of money, but it is a property right. Just like if you buy a house, there's no guarantee that your property is going to increase in value. There's no guarantee that your patent or your trademark or your business will increase in value, but it gives you a foot in the game that's important and valuable. And as she mentioned earlier, you can use it for licensing, and you use people to exclude people from using your property. So we're here at the Blockchain Summit. So what impact, if any, do you believe the Web3 metaverse will have on the USPTO?
So many ways, right? I mean, anything that you've created, whether it's within the metaverse, whether it is the software for the blockchain, it is your intellectual property. Came out of your head. No one else has done it. So, and it has use. Therefore, you can apply for a patent for it. I would have to say, as with any advancements in technology, the advancements usually are ahead of the laws that govern it. So not only at the USPTO and at the Copyright Office, but...
Excuse me, sir, can you, the flash is making me, okay, I'm sorry, go ahead.
Not only in the United States, but across the globe, there are challenges, and we're working together to deal with, okay, now how do we govern metaverse? How do we govern things like NFTs to make sure that people are getting the appropriate protection? I'd mentioned use. So 101, 35 USC 101 is a statute that determines whether what your idea is useful and can get a patent. And that, how we interpret that particular statute is advancing based on the advancements of technologies. In design patent space, it's the 171 is the same type of, is this useful, or is this not useful, but is this associated with something useful? So let's take metaverse. If you've developed this, this store in the metaverse, and you want to put a patent in, or an application for patent for how you've designed that space, one thing you have to do to get over the 171 statute is say that it is linked, associated to an article of manufacture, so something of use. So if I just had, I have this metaverse, and this is one of the things that we're challenged with right now, that if you put these goggles on, that's a good example, if you put the goggles on and you're sitting in the middle of this space, part of what you've claimed or described in your figures for the design has to say that it is linked to those goggles. You can't just say that I'm in the middle of this space without it having that link. And these are challenges because as far as we're going with technology, a lot of the advancements in the technology are trying to decouple the actual space that you're now feeling like you're in with any type of other technology like the goggles or screen or the monitor that you're looking at it on, trying to decouple those. Those are a couple of things that we in USPTO, in IP, in the law aspects of it are grappling with. But now you do have these opportunities, right, in the utility side on the patent to apply because you can get a patent for the software that provides this. On the design side, you may have to identify it as through these goggles, but you can still get that protection. And I tell everyone you don't really know until you make the application and file. So
It's a fantastic point. I mean, and the PTO has a heavy burden of trying to decipher what is an invention and what isn't. And she was making reference to, right, whoever invented the goggles, and then people use the goggles. And so the person gets the patent for the goggles, but then someone else has a claim or has an invention that's related to that. And trying to decipher who invented what, it goes to the courts, it goes to between different companies. It's a huge endeavor, and the patent office and attorneys like myself go back and forth all day long and try to figure out what the differences are and what gets patented and what doesn't, and who can use, what defines someone's invention. So I wonder also, so there's a lot of entrepreneurs in the room, people working at blockchain, people working in the metaverse, but certainly for blockchain, is the PTO going to adopt, is there any chance for people in the room to sell their services to the PTO, to the PTO to adopt, in terms of like databases and record keeping and all these things, these values that the blockchain has? Is the PTO going to use blockchain in terms of their internal resources or internal workings of the system?
That's a completely different area that's a great question that we are looking through right now. AI, artificial intelligence, and blockchain and metaverse, and how do we now use that to improve our examination process to make sure that we're getting the best, the best references, prior art, which are any publication that's out there that we need to take a look at to see if what's in front of us, the idea in front of us, has been done by others. And I tell people all the time, especially with the internet and how close we are to everything in the world now, there are many prior art references out there as there are stars in the sky, and examiners have a very finite number of hours to do their work. So we are looking at AI and other advancements in technology that's going to assist examiners in doing their job. But if I could divert for just a little bit, because it's something that you brought up about, we have a lot of entrepreneurs, we have small businesses in the audience. I'd like to, not that I'm taking anything away from Jesse because he's an amazing attorney, and if you can afford his services, you should use his services.
Thank you.
But we have programs for micro entities and small entities. We have programs like the Pro Bono program, which is a free service for those who are of a certain income level that will help you free of charge to file your application. That is one thing that you should really look into, because I'm not going to lie, it's an expensive proposition to get a patent. It's a legal process, it takes a lot of time and effort, and it takes a lot of money. So there are areas like pro bono or even law school clinics where they will take on clients and assist them free of charge to help them get through the patent examination process. Now, even if you do decide you want to do this pro se, so pro se means I'm going to represent myself at the USPTO. I don't want an attorney or an agent to represent me. We have services at the USPTO, the Pro Se Assistance Center, that helps pro se applicants to better understand a very complicated legal system and how to get through it as your application is being prosecuted. There are training courses as well to help those who are not professionals, legal professionals in this space, to navigate the USPTO. Not only assistance in navigating the United States Patent Office, but also to assist in other areas. There's something called the Patent Cooperation Treaty, PCT. It's an international filing, a place to start with your idea, to apply and say, I am interested in filing in all these other countries' offices as well. So this is the initial that helps you. I mentioned about that filing date. Filing date is very important to protect your idea. It's a place to start that gives you an opportunity to further develop your applications and be able to file not only at the USPTO but in other offices and still have the protection of that earlier filing date.
Yeah, this is fantastic. We can talk about this all day long. This is our favorite topic. So this is my last question coming up, but I'm glad you mentioned the part about the pro bono resources, because the PTO. So at my law firm, we register for the PTO updates. So we get all these updates like daily of all these fantastic programs the PTO is doing, and they're doing a great job right now of outreach and informing people about the different opportunities and programs within the USPTO. And even attorneys like myself can volunteer with the pro bono program to help people who have filed like what they call preliminary patent applications, provisional patent applications, and then help them along the next steps along the way. So my last question is, so what challenges does the PTO see going forward the next 5, 10, 15 years? Or where's the PTO going, if it's not there already?
So a couple of challenges that, that I see for the USPTO. One is advancements in technology and making sure the laws that govern and protect that technology are in place. So 101, I mentioned subject matter eligibility. What actually is eligible to get a patent is an area that's been a challenge not only for the USPTO, but for Congress and for our courts on how to interpret and make sure that we're giving the appropriate protections. Because as I mentioned, it's an expensive game, and especially with large companies, like the Nikes and the Adidas and the Facebooks and all these companies who can be very litigious. They will take you to court. So what we need to do at the USPTO, especially to help the small and micro entities, the small businesses, is make sure that our interpretation of laws is advancing the technology and helping to further protect all of you. And making sure that what is granted as a patent is robust, is reliable, is predictable, is consistent from one patent to the other. So that's an area that we're spending a lot of time on. A second area, because I know we're running out of time, that is near and dear to my heart, and I know to Jesse's, is what I had mentioned before. I am leading a project for the Undersecretary on Council for Inclusive Innovation and building a more inclusive IP and innovation community. And I'm proud to say that the president of Howard is a member of this council, representing not only Howard, but those underserved and underrepresented people in this space, and what do we need to do to build a more inclusive innovation and IP community. So we're doing a lot of work with not only large companies, but small companies, university presidents, government executives, independent inventors, on how do we put forth the right actions, and how do we in each of these sectors of the innovation community come together to make sure that, as the Undersecretary Kathy Vidal likes to say, everyone is born an innovator. but they don't have access to the opportunities necessarily to get them to where they need to be, which not only helps the individual, but helps our nation as we're growing, and to stay at the forefront of the advancements in technology, be a global leader. So we are working to make sure we are reaching every single person in this nation to give them the education, awareness, opportunities to make sure that their ideas meet fruition and go all the way to realization and commercialization, and helping to find grants to get the money to realize those inventions.
Well, this is fantastic. I mean, let's everybody give Valencia a round of applause. I mean, she's had a great career. She started right here at Howard University, engineering. I mean, right. She's a giant at the PTO, and we're happy to have her. Thanks for your all attention. Great to be here, and hopefully to meet some of you all as the day goes on. Thanks.
Thank you.